Hi friends, today we're going to be talking about the U visa green card process. Maybe you have a U visa and you need to get a green card after you have the U visa. It's important that you listen to this video because you need to have a way to maintain your lawful status, and you have the opportunity to apply for a U visa green card. If were in U visa status or are in U visa status, stay tuned so you can learn about the requirements and what you need to do next. All right, let's get to it. Certain relatives of a U1 non-immigrant can also qualify for a green card. This is either as a derivative applicant or a qualifying family member who's never held derivative U status. So what this means is that if you're already on U status, there's one process, but if you've never held U status as a spouse or family member of the main U visa holder, there's a different process. You can apply for a green card if you were granted derivative status as a U1 non-immigrant spouse, child, parent, or sibling. So what are the requirements? You're eligible for a green card based off of derivative U non-immigrant status if you meet the following requirements. You properly file Form I-485. You're in the United States when you file 485. You were lawfully admitted in a U visa status. You are in U2, U3, U4, or U5 non-immigrant status. You've been physically present in the United States for 3 years. This is really important since you were admitted as a derivative U visa status holder. You're not inadmissible under INA section 212A3E, and your presence in the United States is justified on humanitarian grounds to ensure family unity or because it's in the public interest and you merit a favorable exercise of discretion. Now, if you meet these eligibility requirements, you don't have to wait for the U1 non-immigrant to file for 485. You can file the application before or after the main applicant files for adjustment. You also may be able to adjust status even if the U1 never files their own 485. If the U1 adjusts status before you are initially admitted as a U non-immigrant, you will no longer be able to admit it as a U non-immigrant. However, you may still be able to adjust status or apply for an immigrant visa as a qualifying family member. Now you might be wondering, what are some of the things that you need to submit? If you're a derivative U non-immigrant family member, you should submit the following documents and evidence to apply to adjust status. Form 485, copy of the approval notice for your Form 918 Supplement A for the qualifying family member of a U1 recipient, copies of all the pages of the passport. If you departed from the United States while in derivative U non-immigrant status, you must submit evidence showing the dates of each departure, the date and place of each return, and the reason for departure, your own affidavit attesting to your physical presence and evidence of your continuous physical presence, evidence that you were lawfully admitted in U2, U3, U4, or U5 non-immigrant status, and that you continue to hold that status when you file Form I-485, and evidence that adjustment of status is warranted as a matter of discretion on humanitarian grounds to ensure family unity. 2 passport photos, copy of your government-issued identity document with the photograph, copy of your birth certificate, copy of the I-94, the medical exam, and certified police and court records of criminal charges. Now, what if you've never held U visa status as a derivative? At the same time or after applying to adjust status, the main applicant may file Form I-929. This is used to petition for a qualifying family members who have never held U non-immigrant status as a derivative. This could include a spouse, child, or parent. Now, if you're inside the United States and have an approved Form I-929, you may immediately apply for a green card. If you're outside the U.S. and have an approved Form I-929, USCIS will forward the approved petition to the Department of State so that you may apply for the immigrant visa at the appropriate U.S. Embassy or consulate. What is the eligibility criteria for adjustment of status as a qualifying family member who has never held U non-immigrant status? You're eligible for adjustment of status as a qualifying family member if you've been approved Form I-929. You're not admissible under INA 212A3E, and you merit a favorable exercise of discretion. Now, you want to note that the qualifying family relationship that formed the basis of your Form I-929 approval must exist at the time the U non-immigrant becomes a lawful permanent resident, and that relationship must continue to exist through the time USCIS approves your Form I-485. I hope this video serves you for the U visa green card process, and if you have questions, don't hesitate to reach out to us. And make sure you subscribe to continue to get updates. By bettering yourself, you're bettering your family. By bettering your family, you're bettering the world. Thank you. Bye for now.